do want to go over beforehand is I want to reassure everybody, and I'm going to have to repeat this a few times, so I apologize, but I want to reassure everybody that we are going to be dropping all the files that I talk about in the chat. Okay, so we have the ability to drop into the chat and then you can immediately download the files. I'm not going to do it right now because inevitably more people are going to join us. So I'm going to wait till we have more people, maybe an hour from now or so. But I wanted to show you, give you a little preview about some of the kinds of documents that you're going to receive. And I'm going to reference these a little bit throughout the presentation. The first one is our IEP strategy guide. So this guide is basically IEP strategies. Here, let's give you a full page, and it basically has different things so that you can get what it is that you need. Okay, and again, this booklet will be dropped into the chat later on. We also have Enough is Enough, and this is our anti-bullying strategies booklet. And this booklet has a number of strategies that one can use to eliminate bullying. And some of the strategies are school-wide. They're things that the school can do throughout. And then some of these strategies are more or less things that you can introduce into the IEP meeting. So, and I'm going to be dropping that into the chat as well. And then lastly, we have developmental milestones. And we basically compiled this booklet because a lot of people were calling us with the issue of, at the IEP meeting, they were being told that certain skills were too advanced for their young children. And what we found is that there was a lot of bad information out there. And so we compiled this guide by going to numerous websites, you know, child development websites, medical websites, to pull up this information and incorporate it all in a booklet. And so in here we have the kinds of skills that children should be demonstrating by a certain age. So here, for example, you see at age 4, between 49 and 60 months, a child should be able to walk in straight lines. A child should be able to dress themselves as part of their physical development. And we have this all broken down by different areas so that it's a little clearer for you about what kind of skills are actually advanced for your child versus are ones that we would expect your child to be able to perform. So again, we're going to drop all these documents into the chat later on. You'll be able to download them and you will have a copy of all of these documents. Also, one of the things I'm going to be doing is talking about things as if we are not in the middle of a pandemic, okay? Which is not to say I don't want to acknowledge what's going on. But at the end of the presentation, I'm going to cover some additional strategies with the pandemic in mind. Okay, so these what we're going to cover in the training today are going to be issues that should be able to help you right now, as well as after the pandemic is over and we go back to in-person schooling once again. So again, we're going to drop all that in the chat for you to make sure that you've got access to that stuff. And we'll do that just a little later on. Okay, so the first thing I want to cover, and for those of you who were with us last week, this is a repeat, so you'll see this. But I have to do this because the questions that are going to come up, these are the answers. So as you all have questions about what can I do when, generally speaking, this is your range of answers right here. So we're going to cover it. Schmoozing. Schmoozing is basically getting things done with a wink and a handshake. Okay, getting things done with a wink and a handshake. It's getting things done in a way that's informal. And so if you said, okay, you know what, I'm gonna talk to them and I'm gonna see if we can just kind of get it done informally, and you're told, yep, everything's gonna happen the way you want, and then you decide that you want to write a letter because you want to prove the conversation happened later. Boom, you're done. You're never gonna have an informal resolution with people again. They won't trust you because of the fact that you're putting things in writing. So schmoozing takes a degree of trust with the other party. If you can't trust them, then schmoozing may not be an option for you. If you believe that they'll say yes and then in actuality not follow through and do it, then you don't have that trust, and in reality, schmoozing's not an option. But remember, it's getting things done with a wink and a handshake, okay? Then there's IEP meetings. So IEP meetings is basically a much overused strategy that families use, and I'll explain that in a second. So IEPs, you have the right to ask for an IEP meeting at any time. If you ask for an IEP today, the meeting must take place within 30 days. That's what the law says. So you can ask for an IEP. But what we hear from a lot of families is that they've asked for an IEP meeting, they wanted to change something, or they wanted to get a new service, or they needed to make sure that a service was going to be provided. And then they found at the end of the meeting that not only did they not achieve what they were trying to achieve, but then some other services were cut or reduced or eliminated. And so it left people really scratching their heads going, well, then what's the point of having an IEP meeting? Here's the thing. An IEP meeting is a good strategy for when you have to ask for a new service or a change in a service. So if you're asking for something new or a change, then an IEP meeting is great. If you want to hold an IEP meeting because you want to make sure that that the IEP team or the school is providing the services the way they're written in the IEP, right? So at the start of the school year, we often get calls from people who say, "Yeah, I just called an IEP meeting because my child's one-to-one support aid wasn't provided." And here we are in October, and it's still not being provided. So I asked for an IEP meeting. And can you believe what they said? And then we get the question and the complaint. So the thing is that generally speaking, IEPs are great for new services, changes in services, not to enforce the IEP. That's not the purpose of the IEP meeting. It's to review progress or to set goals. State compliance complaints are exactly what you're looking for if you're looking for something to reinforce or to enforce the IEP. So a state compliance complaint is a complaint process that you can use where essentially it's a letter to the Department of Education, to the California Department of Education. So I'm going to use the initials CDE, California Department of Education. You send that letter to CDE. There's also a form you can use, but we don't recommend that. 1 week from today, we're actually going to be doing a presentation on evaluations. And then in January, we're going to be doing another presentation on how to write a state compliance complaint. And I think you'll find that one to be particularly useful. But in your state compliance complaint, the two most common uses for it. So again, remember, it's about a complaint that the school district is not following the law. That's the foundation of what it is. That it's an allegation that the school or the district is not following the law. So one of the two most common kinds of complaints that people make using this process is the IEP is not being implemented as written, which is in the law. And the other thing is that someone is requesting an evaluation or an independent educational evaluation, and the school either hasn't done it or is dragging its feet, taking too long. So a state compliance complaint is perfect for those things where there are timelines written into the law or there are very clear requirements written into the law. So state compliance complaint is perfect for that kind of stuff. Due process. Due process is the option that you use when you need to either appeal a decision in an IEP meeting, or you want to make the allegation more or less that your child has not benefited from their schooling, that there's been no benefit, a lack of FAPE. Okay, you might have heard the term FAPE before, free, appropriate, public education. Okay, and so with a denial of a FAPE, it essentially means that that you're alleging that the school district has not done its job. Okay, you're alleging that they haven't educated your child, and as a result, you want to appeal it. It's also good for disagreements. So if you disagree about something that should be in the IEP or shouldn't be in the IEP, then due process is the appropriate process or the appropriate option for you. Now, generally speaking, we recommend people get lawyers for due process. Okay. Now, if you're doing a regional center appeal, we generally don't recommend you get attorneys. Generally, you can represent yourself with some preparation. Sometimes people need help. That's all fine. With due process and in special education, we always recommend, without knowing anything about anybody's situation, we always recommend that people get attorneys. There are special ed attorneys out there, and they will represent people. By the way, I do see that there are some comments in the chat. I'm not going to pull them up quite yet. I'll wait till I get to the end of this section. Actually, why should I do that? Let me do it right now. Oh, excellent. So we've got the flyers for the 2 presentations that are coming up. And again, evaluations next week, and then state compliance complaints after the holidays in the new year. So you guys can grab those flyers and get all the details. So going back to due process, we recommend you get a lawyer. And here's the thing, it is a legal process. So, you know, the kind of lawyer tricks that you see on TV and in the movies, things that we may not know about terribly well in real life, well, those kinds of things are present in due process. Those kinds of things are permitted. The procedure follows the what do you call it? The rules of evidence, which are very complicated, and they're all designed about what kinds of, or it's all about what kinds of information can be allowed or not allowed into a trial. So a judge, an administrative law judge, makes the decisions from the Office of Administrative Hearings, OAH, the Office of Administrative Hearings, and they make the decision. The reason why we recommend a law is because this is very firmly rooted in, why we recommend lawyers is because it's very firmly rooted in the law. The other thing is that we recommend this too because ultimately, if you have a lot of money in your pocket, then you can afford an attorney, no big deal. If you don't have a lot of money in your pocket, like many of us, then affording an attorney might send chills down your back because we've all heard about how expensive lawyers can be and all that kind of stuff. Here's the thing about it though, is if you've got a case and you win your case, your lawyer gets to recoup their fees from the school district. The district must reimburse you for the fees you've paid to your attorney or pay your attorney's bill. So what that means is if your attorney is confident that you've got a good case, good evidence, good information, can demonstrate everything, then ultimately they may be more willing to represent you free of charge because they're confident that they're going to win your case and they can get their fees from the school district. So this is a way to even the playing field between families and school districts because school districts have tons of resources, lots of money available, lots of people, lots of expertise, whereas families, it's you. And you know, if you have enough money to even pay for the attorney, many of us would be lucky. And so this evens the playing field. Now, what it also means is that you have a responsibility to make sure that your case is well prepared. Because if you look to be like a high maintenance client, an attorney is not going to want to represent you. If you look like a pain in the neck and you represent more work than somebody else, they're not going to want to take your case. Okay. The other thing to keep in mind about working with special ed attorneys is that you're on the assembly line. You're one of many cases that they are handling. And being on the assembly line, they want to touch each case as little as possible. And it's only going to be right before certain key points in the process that you're going to have a lot of interaction with your attorney. So you're going to have the most at the intake meeting, you're going to have the most right before mediation, and then you're going to have the most right before an actual due process. And so again, you want to make sure that your case is well prepared. So all the strategies we talked about at the last week and the strategies we're going to talk about today are geared towards making sure you have a good case to get, or a well-prepared case to present before your lawyer, okay? And also to make sure you understand the fundamentals of the law so that you know if your case is good or if it needs some work, okay? OCR complaints, the next option. OCR complaints is the Office of Civil Rights. The Office of Civil Rights exists within many, if not all, federal departments. So think federally now. The Department of Education has an OCR within it, an Office of Civil Rights. The Department of Transportation has an Office of Civil Rights. So due to our history of segregation with public transportation, as an example. So the Office of Civil Rights is an option. The most common reason why people want to go to this option is because, at least in our experience, is because the school district is doing a field trip into the community, and you're told that because your child is in special education and has behaviors or needs medical care or whatever the thing is that goes in quotes, that they can't participate. So sorry, you're going to have to keep your child at home. Okay, we hear this a lot in fifth grade during the big fifth grade trips. So the thing about that is that if your child is told that they can't participate, that's discrimination on the basis of disability. If your child has a disability and they're discriminating against your child, they're being treated differently than everybody else who can go on the field trip. So the bottom line is the district should be providing the supports that are necessary to make sure your child can participate like anybody else. If they fail to do that, an OCR complaint might be best. And so the thing about this, though, is realize the complaint process, the soonest I've heard is 2 months, and the longest I've heard was a year. So it takes a long time for these complaints to resolve. Understand that if you're told this stuff, your child is probably not going to be able to go on the field trip. You're not going to be able to force them to do it. But by doing an OCR complaint, what you can do is you can basically get the school district to change its policy. You can require the school staff, both the administrators and the teachers, to go through training to learn that that kind of discrimination is no good and has no place in a school. And you'll know that the issue is cleared for people in the future. Because the school's going to have to make some changes in how they do business if this complaint is found to be justified by OCR. And what is it? It's a simple letter. How do you get the information? You go right to the Department of Education, US DOE, Department of Education, DOE, US DOE. Go to their website and look for the complaint processes for civil rights complaints. The link that they have is to the Office of Civil Rights, so you should be able to find it pretty quickly. If you put in just OCR in the search box, you'll find the address, the phone number, all that kind of stuff. So all it is a letter. So you write a very clear letter, and you indicate, look, my child, the entire fifth grade class was supposed to go on a field trip. I was told my child couldn't because of their behaviors and other issues related to their disability. I believe that this is discrimination on the basis of my child's disability. I am respectfully requesting that you investigate the matter. One of the things I would like to see in any proposed resolution is training for the staff at all levels at the school so they don't engage in this behavior again. If you have any questions or anything in this letter is incorrect, please let me know in a reasonable amount of time. That's your complaint letter. That's simple. Only has to be 2 or 3 paragraphs. It doesn't have to be 10 pages. It doesn't have to be every single detail. Okay, so next option, public participation. Public participation usually means testimony at Board of Education meetings, or it means giving testimony at the Community Advisory Committee that's part of your local SELPA. Okay, I know there's a lot of initials in there to unpack, so let me get into it. So again, public participation, Board of Education input. So you can go to those meetings and give input to the Board of Education, and you can give input to the CAC, the Community Advisory Committee of your local SELPA. SELPA is Special Education Local Planning Area. I'll repeat it. Special Education Local Planning Area. The SELPA is, you can think of them as the middleman between the Department of Education in Sacramento, the California Department of Education, CDE, and the school district or school districts under that SELPA. They take the special ed money and they distribute it to the one district or the multiple districts below them, and they can keep some money back for their own use for things that will benefit all students in the district with disabilities with an IEP. And so you can go and give testimony at those meetings. You can give input, and they have to listen to you. These meetings require public input. There's a section where in the meeting where you can give public input on anything you like. And you can also comment on any agenda item as well. So if they're going to be talking about field trips in the 5th grade, well, wonderful, you can go and talk specifically to that. Now, there's one thing that I want you to keep in mind, which is when you engage in public participation, you have a responsibility to put your issue in terms of being a systemic issue. Okay, so if you say, hey, I had a problem, I had a disagreement, nobody's going to care. Okay, the board of directors, I mean, people care, don't get me wrong, but nobody's going to care in terms of what do I need to do, what changes do I need to look at making within the district to solve this problem. The answer is going to be, I don't have to do anything. Because if you say, well, we've got a disagreement in the district, they're going to say, well, we have an option for that. It's called due process. So why don't you talk to one of the staff? They'll tell you a little bit more about it, and then you can do due process. Okay, so if they can point to a process or an option or a thing that exists to take care of the issue that you've raised, fine, so be it, no problem. But the problem is if you want to talk about a systemic issue, you've got to talk about how the machine is not working, how the gear, this is my imitation of gears fitting together. And so the thing is that if things work out the way they should, like if they say, well, we have an option, it's called due process, they can point to those options. So what you've got to do is talk about the problem in terms of the machine isn't working. Either your child's sliding through the gaps in the machine or the gears themselves are grinding up your child. And so you've got to demonstrate that. So one of the ways you can do that is, like, let's say you have a disagreement about the evaluation that was conducted. You can basically say, hey, look, the school district did an evaluation as they were required to do, but it described somebody completely different from my child. It was just the worst thing I've seen from start to finish. And so as a result, and I know there are options, I can do due process and I can get an independent educational evaluation. But the thing is this speaks more to the lack of training that your staff had and the lack of supervision. So one of the things I'd like to recommend is that you have staff, maybe the head of psychology, review the evaluations of the psychologists before they're used in an IEP meeting, because there were so many errors in mine and there was really no safety net except whatever training the staff person had. So I'm making that recommendation because if I'm experiencing this problem, I'm sure other people have as well. And there's no policy or procedure to cover this. Thank you very much. And that's it. So what you've done is you've put this in terms that the school district, the Board of Education, the CAC, the Community Advisory Committee, will have to take and process and understand that the system isn't working well, that there are either gaps or it's grinding people up. Okay, and we recommend doing that information later on, or excuse me, providing that information verbally during the meeting and bringing letters with you, many copies of letters, 25, 50, to give to every single person on the board and to give to people in the audience who might be interested. Maybe you can create allies and create a movement. So that's one way of getting it done. Okay, another option. Letters of understanding. Okay, this is our own name for it. If you do a search on Google, you may have a hard time finding it. I have found it under letters of understanding. It's not terribly common. The thing is this, a letter of understanding is a letter to document and memorialize that something happened. Okay, all it is just to create evidence. That's all it does. You're writing a letter to say, as you know, yesterday we spoke and you said this and I said that, and you said this and I said that, and you said you would look into it and have an answer for me within 2 weeks. Thank you very much. I appreciate your hard work. If anything in this letter is incorrect, please inform me within a reasonable period of time. Now, that magic phrase at the end is a phrase that you should include in every letter that you ever do. And the reason why we recommend that is because if there's no response to your letter, which is a common experience for many people, we're told that, well, we're told most people, they don't get responses to their letters. And it can be very frustrating. But in this case, their silence works in your favor. So no response makes it look like the information in your letter is factually correct. Then later on, if there's a disagreement or a problem, 6 months later, a year later, even 2 years later, your letter of understanding acts as evidence. And it's not your word against theirs, it's your written evidence against their verbal word. So it really stacks the deck in your favor to use letters of understanding as a tool. We're going to talk about that a bit later on in the presentation. But again, always include this magic phrase. I wouldn't change it very much, but the gist of it is, if anything in this letter is wrong, please contact me. And the reason why that works is because if they don't contact you, you're left with a certain understanding of what's been happening. If you have to do an appeal later, like due process, and you say, well, this was my understanding, Your Honor, and the school district says, yeah, but that was all wrong, totally wrong. Parent got it totally wrong. And then the parent can say, yeah, but I sent you a letter and I asked you to tell me if I got it wrong. And you didn't say anything, so I assumed it was right. The judge is going to say, yeah, what they said. Okay, the judge is going to say, yeah, you have a responsibility to correct the family's wrong impression if it's wrong. And your silence kind of meant that it was right. So sorry, we're going to proceed as if that was their understanding and that was proper. Thank you. So letters of understanding are a tremendous tool in the parent toolbox, probably the most underutilized tool. Now, one of the things you got to do is give it to them in a way that you can prove that the school district received it. So there are a couple different ways. One is registered mail. And so registered mail, it's half the price of certified mail. I think a lot of people know certified mail. It's the green card that comes back to you. Registered mail is the pink card that comes back to you. So you fill it out, and basically the post office will deliver it. They'll require someone to sign the pink card, and then they'll mail the pink card back to you. So what you do is you always have a copy of the letter that you sent them, always have a copy, and then you attach the pink card to the copy to prove that they received it. And so later on, 6 months later, if you have to look into it or check it, you can. It's right there stapled to your copy. Okay, so that's one option. Another option is fax machine, but it's got to be a special fax. And I know hardly anyone's using fax machines these days, but you might want to get a fax, or if you have a fax machine, make sure it's one that can produce a confirmation page. I think most people are used to those now. Confirmation page with the date, the time, the phone number you sent it to, number of pages, all that kind of stuff. But then it also has to have a miniaturized copy of the first page of your fax, the first page of your fax. That's important to prove that you sent the fax. So when you put your letter into the fax machine, no cover letters. Address it and make it look like it was a letter that you were going to put in an envelope, and then just put it in the fax machine. It's up to the school at that point to get it to the right person. Okay, same thing with registered mail. Once you've got proof they've got it, it's out of your hands. Okay, you can also give a copy of the document to the school district where they do a stamp and the date and all that kind of stuff. So you can say, look, I've got a letter for you. Would you mind just stamping it with the date and the district name, and then making a copy and giving me the copy, just so I have proof that you received it. And usually the district will do this, no problem. And so you get it done, no problem. The thing is that if you may find yourself surprised that you cannot do this anymore. You may get told by the secretary of the school, look, sorry, we can't photocopy and give you that proof anymore. And sometimes parents tell us they get really ticked off, really angry, and they take it out on the secretary. Our recommendation is don't do that. Instead, just say, okay, I understand. Feel free to keep that copy and I'll take care of it. Thank you. And then you send it registered mail or via fax or one of the other ways. Rights law. If you don't know about rights law, check out rights law. It's WRIGH WRIGHTS, like the Wright brothers, WRIGHTSLAW, Wright's Law dot, I think it's .com, might be .org. So at Wright's Law, they have a great article about the potential negative impact of certified mail. And then they have a way where you can give the document to someone in person. And by making notes on your copy of the document, like what kind of clothing the person was wearing, their name, the date and time, other people who are around, the configuration of furniture around the room, all these kinds of details also suffice as evidence that you provided the letter to the school. Now, the thing is that a lot of times parents tell us they'll do one of these things, they'll deliver letters in one of these three ways, and then they'll be told, oh, we never got it, sorry. And my recommendation is to say, well, look, I made sure it got to your front door. After it gets to your front door, I'm sorry, but I can't be responsible. It's not like I can go into people's offices and hand deliver it. We're actually not permitted to do that. So I'm sorry, I can't take responsibility for that, but I'll be happy to provide you with another copy of the letter. Happy to do that. I'll bring one tomorrow, or I'll email it to you, or whatever. You can do that, okay? Now, so that's one thing to keep in mind. If they say they never got it, that's not your problem. Now, I certainly would not say to them, not my problem, wouldn't do that. But you certainly can say, I understand, and I'll be happy to give you another copy. But understand the request that was made in that letter, there are timelines in the law for when that must happen. And because I met my obligation to provide it to you, those timelines have already begun. But for convenience sake, I'll give you another copy of the letter. No problem. And that's that. Okay, there's a question in the chat. Parents have shared that district employees will text or call in response to their letters of understanding. Do I have any tips on handling this type of situation? Yeah, I do. As a matter of fact, let's throw email in that too. A lot of people ask, well, can I use email? Can I use texting? Can I use, or district staff are going to text or call in response. That's fine. Here's my recommendation. You write another letter of understanding. That simple. As you know, I sent you a letter with concerns about my child's behavior at school or whatever it is. You called me up the next day, which was yesterday at 4:30 p.m., and we talked for about an hour of it. Thank you for your time. You indicated that you did that you would blah, 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 and I would blah, 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 blah. Thank you very much. If anything, this letter is incorrect, please let me know in a reasonable amount of time. And you're done. So all you got to do is memorialize that contact. Okay, pretty simple. And again, if email is more natural for you, or texting or whatever method you use, keep doing that. Keep doing it. But then periodically, like clockwork, I would do a letter of understanding every couple days, every week, every 2 weeks, depends on how much communication you're exchanging. The thing is this, you can't wait too long. If you wait too long, what'll happen is the issue will grow stale and your letter will read weird. It'll just sound weird. And so my recommendation is to make sure to avoid that weirdness is to just write those letters with some degree of frequency. Okay. What degree of frequency? I don't know. It depends on your situation. Generally speaking, once a week sounds good to me. Okay, whether it's every Monday or every Friday. Mondays make more sense to me because you usually have a little more time on the weekend to do it. Other people, that doesn't make sense. They'd rather do it every Friday. It's fine. Do whatever's right for you. But the bottom line is you want to have a letter where you've memorialized those conversations. And the reason why is because special education attorneys have told us that in their experience, about half the time, judges will not take printouts of email conversations. They will not accept it as evidence about half the time. Okay. Now, whether that's changed over the years, I'm not terribly sure. But the point is this: why take a chance? They will take letters of understanding as evidence, always. So here's the thing: if you've ever printed a conversation in email, it's huge. It's immense. It's like a stack of papers. No judge is going to want to read that as part of a due process hearing. But reading letters of understanding that are summaries of this kind of stuff, excellent. Your letter of understanding should be no more than a page, maybe 2 pages tops. Okay. And by the way, when you write your letters of understanding, remember, even though you're sending it to the school, that's not your primary audience. Your primary audience is the judge or the Department of Education who's going to hear your complaint in whatever, 1 month, 6 months from now, a year from now. So it's really important that you remember your audience is the judge or the administrator at the Department of Education. Okay. Now, one thing I'm going to go back because I realized I forgot to cover something was state compliance complaints. You can do these for issues as much as 1 year old. You can go back 1 year to do a state compliance complaints. With due process, you can go back up to 2 years. Okay. So that's important to know those timelines. Okay. All right, moving on. So those are your options. That's basically your full range of options. If you ask me a question about what do I do when, the answer is going to be one of these. What is this? 8 things, 6 and 5 on this page. 2 more, 7 things. It's going to be one of these 7 things. Okay. There are some other options that exist, but they're rarely used and they're used in very unusual circumstances. So I'm not going to get into those kinds of things. Now, one of the things that you have to remember is that right now, getting services through the IEP, it's a deficit-driven process, meaning in order to get services, you've got to talk about the things that your child cannot do. And we know that this is horrible. We know that this is horrible. We know that you're constantly fighting with systems, with people, individuals, that to get them to understand that your child can do stuff, that your child has capabilities. Sometimes parents tell us before the IEP, they end up crying and making the list of things that their child can't do. And then after the meeting, they'll have a good cry because of the frustration or just having to talk about their child in negative terms. However, the thing to keep in mind for you is that without talking about the things your child cannot do, you're not going to get services. If all you do is talk about how proud you are and all the wonderful progress and the things that your child has made, that's all you talk about. That's cool. That's great. You should be a proud parent. But if that's all you talk about, then unfortunately, it's going to result in pretty much no services or few services. The other thing is the family perceptions of school staff. One of the things we hear is sometimes parents really demonize school staff. I mean, I can make a lot of jokes about it. Sometimes it is funny, but the bottom line is that you got to remember that generally speaking, people want to work with children because they want to do right by kids. They want to help kids out. And so you should keep that in mind. Not everybody at the IEP table is evil. As a matter of fact, it may very well be that no one's evil. But what we want to do is make sure that you understand the dynamics at the table. So we're going to talk about that in more detail in a little bit. The other thing is that the district only has the requirement to provide an adequate education, not an optimal education. So the thing about that is the way that's defined is that if your child makes their goals, their IEP goals, then the school district has met that obligation to provide an adequate education. So if the goals are met, it's evidence that the district has done their job. Okay. Now the district can say all day long, we provide the best education possible to prepare students for adult life. We do the best. They can say best all day long. You can never say best. And the reason for that is because if you say, look, 40 hours a week of ABA is the best service, is the best intervention to meet my child's needs, boom, you automatically took it off the table. Just by saying this is the best thing, it's now not an option because the school doesn't have to do the best, the school has to do adequate. So the school may use language like the best all day long, and they can. You can only use adequate. So instead of saying 40 hours a week of ABA is the best intervention based on my child's needs, instead I would recommend you say 40 hours a week is the adequate intervention that my child needs to have to have their needs met, blah blah blah. Okay, so just change the word from best to adequate. That'll take care of it in every situation. Okay, so keep that in mind. Regional centers, they have to provide the best. They have to provide optimal. School districts, adequate. And that's based on case law. Okay, on a court case. Okay, the structure of the IEP. We talked about this last week. I'm going to go over it very briefly. But in every part of the IEP, it's to identify different things about the child, about the student, so that we can get to an overall program that will meet the child's needs. So evaluations are done because ultimately the school district doesn't know your child. So an evaluation is the objective way of making sure that they get to know your child, that they identify the things your child does well, and more importantly, the things that your child cannot do well. Okay. Present levels of performance are taking that information of the things your child does well and doesn't do well and putting it into common everyday language, breaking it up by topic, like gross motor skills, fine motor skills, academics, reading, writing, math, etc. All that kind of stuff. That's based on the evaluations. Goals and objectives are based on the present levels of performance. If there's stuff your child can't do, then ultimately you should have a goal written to make sure that your child learns how to do it. Those are based on the present levels of performance. The accommodation and modifications are generally changes in either how a student learns or what they learn. And with those changes, they're based on the evaluations, generally speaking. So the evaluations are going to tell us areas of strength as well. So if we learn that your child is not a great auditory learner, right? Let's say that's an area of weakness. That's an area of deficit. Your child does not understand spoken stuff too well, but your child does really well with visual stuff, right? Usually we see this, not always, but usually if someone's good in one area, they might have some deficits in another area. And so if your child's a visual learner, then what that does is that strength of being a visual learner, you can write an accommodation to that, such as information that's presented auditorily or verbally will be also paired with written materials as an accommodation. So that written material will play to your child's strength, your child's ability to read well. And so that's one way of avoiding those problems of that deficit related to not being an auditory learner. If it's verbal, it's hard. There's an additional hurdle that it has to go through in the child's brain. Okay. Services are usually based on the goals. The services are what is needed in order to make the goal. So in order to achieve the goal, in order to meet that goal, the services are what you provide to make sure that happens. Okay. And then placement is usually based on the services, the accommodations, modifications, and the goals as well. Okay. And each one more or less leads to the other based on the way I've explained it just now, such as the accommodations and modifications tend to be based on the evaluations. Okay, moving on. So a lot of families approach this process backwards. Okay, not really, but let me just work through this example. So a lot of times families sit there, they don't say anything during the meeting. The school talks about evaluations. Parents usually sit there and go, okay, yeah, evaluations. Yeah, okay, present levels of performance. Okay. And then when they get to the services, the parents say, oh my gosh, I totally know everything. Here it is. My child needs an hour of OT, an hour of PT, an hour of this, an hour of that, 2 hours of that, 30 minutes of this, and you get into all of it. The problem is that your request doesn't have a foundation. So if you wait until the very end of the meeting to talk, and you talk about the services that you want for your child, the problem is if you don't have the foundation earlier, you're not well prepared. That request for a service is coming out of nowhere. There's nothing to hang it on. So what you want to do is make sure you build that foundation. So, you know, and a lot of times people have scratched their head saying, oh my gosh, how did I leave the meeting and not get an answer to my request? So the thing is, obviously, or hopefully obviously, parents do not approach this process backwards. They don't. What families tend to do is do so much evaluation of their child, constantly analyzing everything about their child, constantly figuring out what are the goals, what are the things I have to work on, and then you focus on, okay, if this is what we're working on, this thing, this therapy, this service, this whatever is necessary to make sure my child can do that. So what comes out of your mouth? This thing, the service. And you don't necessarily cover with the IEP team the evaluations that you've done, the present levels of performance that you've created, and the goals that exist in your mind. So you've got to actually explain that stuff. Now, the thing is, many people are going to be at that table. They're going to have lots of initials after their name. There's psychologists, there's all sorts of people. And the thing is that nobody, regardless of the letters after their name, nobody's going to know your child as well as you. You're the expert on your kid. So that information needs to get out there. Okay. So one of the things you may want to do is submit what we call a parent report. And the reason why we would recommend you call it a parent report is because the law says that the school district must consider any report that you give them. So give them a piece of paper that says parent report at the top. Now they have to consider it based on the law. Now they can consider it by going, okay, give us 30 seconds. We're going to read your evaluate. We're going to read your report. Okay, we've read your report now, and we disagree with everything, and we want to move on with the meeting. Okay, they can do that. I've read it. I've considered it. I've rejected it. That's permitted. Now, if they go, no, we're not going to read it. I'm not going to go over that. No, we don't have time for that. Okay, they're not following the law. Okay, so bottom line is they have to consider it. Now, what does consider mean? That's the next question people usually ask. What does consider mean? In the law, if we're asking a question like that, what does consider mean? What do? We go to the dictionary. Not kidding. You go to the dictionary, you look it up, and you look up what consider means. Now, generally speaking, what I like to say is I like to follow the same format that the school did. If they generally read every letter or every single word in a report, in an evaluation, then they should do the same with yours. If they do summaries of it, then you should give a summary on it. And bottom line is that the team does need to go through some process where they go, well, what do you think? I'm not sure. I don't agree. Yeah, I'm not terribly in agreement with that. Maybe I am, maybe I'm not, whatever. And then they give the answer. Okay. If they do that, that's considered, that's okay. They're following the law. Okay. So keep that in mind. But we recommend that you do a parent report and structure it like the IEP. Build it like the IEP. Have an evaluation section, your evaluation of what you've observed, present levels of performance, putting that in the plain language and putting it in terms of the things your child does well and the things your child doesn't do well. Write your own accommodations and modifications, your own goals. Write everything. Write it up as a parent report. The reason why we recommend that is because oftentimes school districts will use it as a defense in due process that they, how can I say that? That they didn't know. Oops, we didn't know that that was an issue to the family. And so because we didn't know in our ignorance, we never talked about it. Well, a parent report makes sure that they did know. And so if they did know during due process, they're going to have a very hard time defending their actions. Again, remember, in order to avoid due process, we're preparing you for due process. Number one, I want to make sure that you can get the services of an attorney free of charge if you can't normally afford it. Number two, by preparing for due process, look, let's put it this way. If you're a school administrator and you need to decide which cases you're going to fight and which cases you want to settle, do you want to fight the person who has a mountain of paperwork, a mountain of letters of understanding that describe every interaction with the staff over the last 2 years? Do you want to go against somebody in hearing who's got independent educational evaluations, who's got access to an attorney? Or do you want to go against the family that has no written evidence? Everything's your word against theirs, and ultimately, they're not terribly active. Me, I'm going to put the effort into the people that I think I'm going to beat. I'm going to win. Okay. Now, the people who've done all that preparation, they've done all that work on the front end. I don't want to go against them. They'll beat me. They're too well prepared. I don't want to go against them. I want to settle with those people. I want to make a deal. So, in order to avoid due process, you have to prepare for due process. That's the logic. Here are rights laws of adverse assumptions. And the reason why, well, I'll get into it. So assume you must request due process to resolve your disagreements with the school. So right away, we're just going to assume that writing a letter to the school is not going to resolve the problem. Schmoozing people didn't resolve the problem. We're going to assume that whatever the disagreement is, you're going to have to go right to due process. Okay? Why? That's the common experience of many people. You have to assume that you will request the hearing. That means the burden of proof is on you. You have to prove your case to this level, not to this level. By having the burden of proof, you've got to demonstrate your case to the highest degree possible, so that I am completely sure, or almost entirely sure, that you are correct. That's a high standard to meet. Then you can assume that all school staff will testify against you and remember the opposite as you. Okay. Now, a lot of times people roll their eyes when they read that and they go, oh, okay, that means that they lie. Okay, the school lies. I can't say that. I don't know their intent. That said, it is a common experience that many people report that the school remembers the opposite as they do. So that's what I can say. Okay. Assume the hearing officer is biased against families. This is not a matter of opinion. This is a matter of fact. And the reason why is because if it's your word against the school districts, the judges are instructed to go with the school district unless the credibility of the school district is in doubt, unless they can't believe them. So right away, that's a bias against families. Right away, just automatically, without knowing anything about any case, they're going to believe the school district over you, unless they think the school district is lying or incorrect in their facts. So that's a huge bias. And then you have to assume you cannot testify. Your lawyers generally don't want to put you on the stand. So how do you prove your case if you can't talk? Letters of understanding. That's why it's one of the most underutilized and best tools in the parent toolbox. A letter of understanding is how you can tell the whole story. You'll never have to talk if you write letters of understanding frequently enough with sufficient detail. And again, don't get into every detail. Don't put in like, I walked down the hallway and you gave me a weird look. You didn't smile, and so I didn't smile back. And the next time I saw you, and nobody cares about that kind of stuff. Okay. Now, if someone ends up yelling at someone else, if someone ends up name calling, sure, that stuff's relevant. But you don't want to get into the ticky-tacky little, and then you looked at me weird and you gave a look, an expression on your face that indicated you were being sarcastic. Don't get into that stuff. Okay. The facts alone are generally going to be on your side. Okay. Now, why document? So first of all, let's talk about what do you document, and then let's talk about why. Okay. So the first thing is you want to have a contact log. Okay. Now, whether this is something you keep on your phone or something you put in writing, something you handwrite, something you do on your computer, whatever you choose the thing that's easiest. For me, I like to do things writing. Okay, I'm holding up a book, which my virtual, okay, there we go. So I like to do things in writing. I have my calendar in here. I have conversations in here. I have my notes for meetings in here, all sorts of stuff. Bottom line is that works for me. If this is ridiculous to you, don't do it. Use your phone. A lot of people use the note application on their phone to take notes and write that kind of stuff down. You absolutely can do that. Okay, but my recommendation is to have a contact log somewhere. Now that contact log should have a couple of different columns, a couple pieces of information. You want to have the date, you want to have the time, you want to have any witnesses to the conversation written down there. And then you want to have your notes about what was discussed. Okay, so you want to document what was the conversation, what was the outcome, all that kind of stuff. Just enough to remind yourself. Doesn't have to be every detail, just enough to remind yourself. So if you read it 1 year from now, you will remember what that conversation was about. That's why you do it. The other thing is you want to do it in, you don't want to give this to anybody else. Don't tell anyone it exists except your lawyer. Okay. And the reason why is it could be subpoenaed. They could ask for it from you and you may have to provide it in hearing. So just don't tell anyone it exists except your lawyer. That's all. Correspondence, any letters you get from the district, any letters you give to the district, you want to have copies of that in the file. So you should be maintaining a file. A lot of independent living centers, a lot of family resource centers are fabulous. And a lot of them offer classes on how to maintain a file for your child in special education. My recommendation is to take that class, okay? Generally speaking, I'll give you the high points in the class in 2 minutes. Here it comes. Put everything in chronological order. So as you get it, put it right on top in the binder or the file. Just put it right on top. Do not use sections. Don't use sections like IEPs, evaluations, letters. Don't do any of that stuff. Just put it in chronological order. Every time you get a document, write down in pencil very lightly in one of the corners. Doesn't matter which one, but trying to use the same corner every time. And lightly in pencil, write down the date you received it. So just write received or RECD and then the date. Okay. And the reason why is because a lot of things in special education are generally based on timelines, on timelines that are written into the law. The law frequently says, okay, you've got to do this within 30 seconds. You've got to do that or you got to do that in 30 days. You got to do this in 1 week. You got to do this in 10 days, et cetera, et cetera. By putting everything in chronological order, you're in good shape because you will be able to track that stuff easily. You'll have received when. And so you'll always know how many days it took for a response or from when something got generated. Letters of understanding, those help you document things that happen, evidence that occurred. So again, you want to make sure that you maintain those and you want them in order to be able to prove things later. That's all it is. It's about providing proof later so that we take it away from your word against theirs to your written evidence against their verbal word. Okay. Again, we want to stack the playing field stack the playing field. Okay, we want to tilt the playing field in your favor by stacking the deck in your favor. All right, there we go. So we want to stack the deck in your favor. And so that documentation does that. All right. Again, you want to prove that they got it. Okay, here's a link to the article about the possible negative impact of certified mail. And so if you click this link, you will find that, and here, let me stop my sharing and change my screen share over to the article itself. And so right here, you've got an article. I'll fix it, give me a sec. The negative impact of certified letters. And so they talk about what that negative impact may be and how to work around it. So it's a very helpful, it can be a very helpful article. So getting back to the presentation, and then you always want to keep copies for your records. Now, how you do that, if you have access to a photocopy machine, great. If you don't, hey, take a good photograph with your phone camera. Okay, if you don't have a phone camera, then I suppose you're going to have to unfortunately buy a camera. Okay, but buy a digital camera or pick up a cheap phone that has a decent camera, just good enough so you can read the letter later so you can print it, so you can email it to yourself. And so just you need a copy for your records. Without copies of these letters of all these different things, you're going to be sunk. So you want to make sure you have those copies. Okay. The other thing is you want to become an expert. Okay. And that's easy to say. I mean, it almost sounds like a joke. Like, yeah, just become an expert. Just, on your own, just study. But that's basically what I am saying. So here's the thing. You want to become an expert because number one, you got to understand the evaluations and their recommendations. What do they mean? So you've got to become an expert on some level, at least to understand evaluations and what the recommendations are. The other reason why you want to become an expert is you want to be able to ask appropriate questions during the IEP meeting. Okay, because you're gathering evidence. Okay, that's what you're doing. Now, you're going to be asking questions to either get what you need. So you ask those questions, and hopefully by asking questions strategically, you can get to the outcome you're looking for. And I'll talk about that in more detail in a minute. And you want to ask questions to prepare for due process. So bottom line is you want to prepare for due process. It's basically you're creating evidence. Got a question in the chat. So in the letter of understanding, I can write down an incident that occurred in Zoom or in school, an incident like my child getting in trouble. And the answer is yes. That's exactly the purpose of it. So I'm going to get a little bit more into it in the next slide. Let me double check. No, not really. So let's get into it now. So I'm going to rewind a little bit and get back to letters of understanding. So letter of understanding, it's to document and memorialize something that happened. That's all it is. It's to document that something happened. An incident is a great thing to put in writing because you want to demonstrate what was the incident, when were you told, when did this happen, et cetera, et cetera. And so a letter of understanding will document all of that. How about later on when you get told at an IEP meeting, look, your child's just fine in that area. You don't need any interventions. So we're going to deny your request for that service. Well, what if you have a letter of understanding that says, yeah, but my child's not just fine. If you remember, there was that incident about 6 months ago where my child was eating inedible objects on the playground, endangering my child's health and safety. You may remember that's when we decided to enhance my child's supervision on the playground. And despite enhancing the supervision on the playground, my child still is continuing to have these issues that endanger their health and safety, which is why I've made the request for blah, blah, blah during this meeting today. So again, I'm going to ask you to reconsider that decision. Letters of understanding create that foundation and that evidence that you'll need later. So it's very important. Now's a good time to remind everybody that, first of all, I got a question. Are you going to get a copy of the presentation, and is there a chance you can get a copy of the meeting? The answer is yes. So later on, at the end of the presentation, I'm going to be dropping the files that I've used in this presentation, including the booklets that I showed you earlier, like the IEP strategy guide or the anti-bullying handbook. We're going to put all that stuff in the chat, and you'll be able to download it later. And someone just sent me a compliment. Thank you very much. I'm glad I'm making you happy with this presentation. And so I say completely sarcastically right now, yes, I hate doing presentations. They're awful, terrible things. Just kidding. I love doing it. I hope you can see that. Anyway, so again, we will be dropping the presentation, and this meeting is being recorded, and we are going to be putting this up in some place on the website. We're kind of figuring that out right now, but it will be available and you'll be informed. Tamika's excellent at making sure that you know what those options are. And in response to the thank you, you are most welcome. It's my pleasure. Okay. So here's the thing. Going back to, here we go. Understanding, you got to become an expert. You need it to ask questions strategically, which I'm going to talk about in a second. The other thing that you want to do is, in becoming an expert, my recommendation is to choose one maybe 2 topics each year. Okay. Information's out there. The internet tells us, we know there's information out there, loads of information. There are libraries. There are family resource centers with libraries specific to the kinds of things that we all are interested in. You can get books to learn about anything. My recommendation is in year 1, learn about your child's diagnosis in great detail. And I understand many of you are past year 1 now, but let's pretend, or maybe if you meet new people, you can pass this advice along to them or pass it along as a suggestion. Year 1, diagnosis. Maybe the second half of year 1, all the different therapies and which ones are appropriate for your child or for that diagnosis. Okay. Year 3 might be diving in to one of those therapies. Maybe year 2, maybe you're going to dive into occupational therapy, learning what it can do, learning that there's more to it than just body positioning, that it's also about sensory issues, that it's about maintaining and controlling your level of activity and energy level. So reading about these things and becoming an expert on them in an intentional way can make a huge difference in terms of the database that you can draw from, in terms of the knowledge that you will have. But here's the thing, by becoming an expert, you will then understand when you get correct information and incorrect information. And if you get incorrect information, you can ask questions to demonstrate that the information is either incorrect or that more or less you're being fooled. Okay? So by becoming an expert, you'll recognize these things. And ultimately, what you will do is create the opportunity for you to recognize when this happens and to ask proper questions. Now, again, you're going to do this in order to get the service you need. You can ask a question and you can change their mind. You can change the mind of the listener. But you can also ask a question to demonstrate that there's certain kinds of evidence, and it will prepare you for due process. You're creating evidence by asking those questions, okay? So now you've heard me say over and over again, asking questions, asking questions, asking questions. So why ask questions, okay? First of all, questions are collaborative, okay? When you ask a question, it's collaborative. You're not dictating, you're not yelling, you're not doing any of that stuff. You're being collaborative. Here's the key. The law says that the IEP team must be collaborative. They have to be collaborative. Are they being collaborative if you ask a question and they refuse to answer it? Are they being collaborative if they refuse to answer your question? No. So if you ask a question, they're either going to answer it or they're not. And if they don't answer it, they're not being collaborative. They're not following the law. If they answer it, you're generating evidence. Okay, you're preparing your case. Now, when you ask questions, don't ask them like when you watched your latest attorney, your latest attorney movie, LA Law or one of these kinds of shows, or even Dateline. Sometimes they show stuff in courtrooms and all that kind of thing. My wife is addicted to Dateline. So the thing is that when you see lawyers firing off questions like that, it's almost like an attack, right? You can almost hear like bullets flying as they're asking those questions. It's almost like there's a cadence to it, and it almost has an attack feel to it. You don't want to do that. Okay? You don't want to do that. You want to ask your questions in ignorance. You want to ask your questions. Hi, I'm a dope. I'm an idiot. I don't know this stuff. I need your help. Can you please help me? Okay, that's what you want to project. Obviously, you're not going to want to say those things, but the bottom line is whether you know the answer or not, what you want to project is, I'm asking for your help. Can you please answer this question? Because the minute you fire off questions and it feels like an attack, done. The person you're questioning is going to get defensive. People are going to circle the wagons. They're going to start covering for each other. But if you ask a question in ignorance, like, I'm sorry, I just don't know anything. I'm just a parent. I'm not a professional. I don't know these things. Can you help me? People generally want to help you, right? Think about how many times you've driven down the road. It happens less often these days, but how many times you drive down the road and people do that gesture, like rolling down a window, and they want to ask you directions, right? Generally speaking, people want to help each other. Generally, maybe not, but the bottom line is that when you ask a question, it generally, if you ask it the right way, people want to help you. Oh, poor little thing. Yeah, let's help them out. They can't be like that, right? So that's one thing. The other thing is, if you ask questions strategically, you can change the person's mind. But did you consider blah, 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 blah? Well, when we talked last week, you said this and that. Are you now saying something different? Are you now? You can ask questions. Well, wait, I thought the occupational therapy standard was to have a tri grip or a quad grip. So why are we talking about making sure my child can hold the pencil like this, where the or the crayon, so that it sticks out like down here? Doesn't make sense. I don't know. Can you help explain that to me? Okay. These are things you can do when you know the information, when you're an expert. Okay. They also prepare you for due process. Okay. Now, unfortunately, I failed to prepare for something, but I'm going to stop sharing right now, and I'm going to try and find a YouTube video really quickly because I want to show this. And I'm going to go to pull it up. I apologize for this. Okay, here we go. So I'm going to get to the right page. Okay, let's get me through a commercial. And once we get through this commercial, here we go. We'll share it. So let's go to screen share. Let's go here, open it up. So this is an example of asking questions. So one of the things that you may want to do, whoop, sorry about that. Let's let these ads, here we go, we can skip. So what I want to do is show you this video. Let's make it full screen so it's easier for you to see in here. And basically, this is about asking questions. So many of you may know Whose Line Is It Anyway? Some of you may not. It's a comedy sketch show. It's all improv. They do everything through improvisation. And the show is basically, and so they do these little skits. So in this case, the skits that they do is called, this skit is called Questions Only. And the comedians can only speak using questions. If they speak in a sentence, then they get kicked out and someone else gets buzzed in, and they trade off, and we're supposed to laugh along the way. So in doing questions, there are ways, sometimes we want to make statements, and what you can do is just change it around a little to turn it into a question. So sometimes you want to say something like, well, IEP meetings have to be held within 30 days of the request. Well, how can you turn that into a question? Don't IEPs have to be, don't IEP meetings have to happen within 30 days of me requesting one? Easy. So this kind of illustrates that, and it gives you a little break to have a chuckle. So I hope you guys enjoy this. 3 minutes.
Chris, we can't hear the video.
Pardon?
We cannot hear the video.
You can't hear, oh gosh. Okay, let's see if I can correct that. And if I can't correct that very quickly, we're not going to do this. Oh, share computer sound. Yay. Thank you. Someone told me that in chat. All right, let's back up. I have to install the Zoom audio device. Okay, we're not watching the video. So here's what we're going to do instead is I'm going to take the link, and I'm going to, here, let's stop sharing first of all. You guys don't need this. And I'm going to take the link and copy and paste it into the chat, and you all can view this later on for your own entertainment. So I apologize for that. You can tell I don't share audio very often on this. So please, if you can, check that video out later. But here's something that you can do as well, is your homework assignment. Yep, I'm giving homework, is to watch a Peter Falk Columbo movie. So some of you may actually know who Columbo is. Columbo's a police detective. This was a very popular movie series and short-lived TV series about a cop in LA who investigated homicides. And he played this routine where he pretended to be a cop who doesn't know anything. He acts stupid all the time, and he gets made fun of it, and that's part of the gag. But really, the guy is incredibly clever and strategic, and the way he asks questions are super strategic. So a lot of times people want me to spend more time talking about asking questions in this presentation. That's some of the feedback that we get sometimes. And unfortunately, with all the other information we have, I can't spend much more time on this topic. But what I can recommend is that you watch a Columbo movie or TV show, and they're available in other languages as well. I've seen Columbo on our local Spanish-speaking television station, public through over the airwaves. And basically, you can watch these movies. Please watch a Columbo movie and just get a sense of the style, because that's the style you want to emulate. You basically want to ask questions in ignorance. You don't want to ask them on the attack. That's not the purpose. Okay, enough about that. And I'm going to double check the chat just to make sure I got everything. Letter of understanding, copy of the presentation, yes. Need to share with voice, yes. Sorry about that, I apologize. And there we go. But again, I dropped into the chat the link to the video. And oh wait, I direct messaged it to one person. So let's make sure I send it to everybody. There we go. Glad I double checked that. All right, so let's move on. So questions are strategic. Questions are collaborative. Now, the other thing is, who doesn't like a free meal? Okay, so there's kind of, I don't even want to say there's a debate, but some people feel that you should bring food to an IEP meeting. There are other people who feel this is a ridiculous idea and you shouldn't do this. Okay, so here's the thing. You got to choose what's the right approach for you. Okay, personally, I like food. Okay, that's a ridiculous state. You guys, but I like food at IEP meetings. To me, they express a couple of things. So number one is they express your appreciation. Okay, now some parents have said to me, oh, but there's some people at that meeting I can't stand. I hate their guts. No way, I can't bring food. Fine, but usually there's at least one person who you deeply appreciate at that meeting. Maybe they did something special for your child. Maybe they're just a great educator, whatever. There's usually somebody that you appreciate. Well, bring the food for them, okay? But feed everybody, okay? Don't be rude. So feed everybody, bring food to them to show your appreciation, okay? Even if it may not be there for every single person at the table, that's fine, okay? You wanna create a relaxed setting. Coffee, bagels, whatever the thing is, pan dulce, that's my favorite. You bring and it becomes a conversation piece. It relaxes people. Food is like social grease. It's like oiling the wheels. It just makes things easier. People are just in a slightly better mood. Okay. Will it change their mind in and of itself? Probably not. If they're on the fence about something, could they decide in your favor? Yeah, sure. Okay. So it creates a more relaxed setting. The other thing is a prop. If you've got to say something uncomfortable, or if you ask a question that's uncomfortable, you can make a joke about it. You could say, okay, wait, no one's answering my question right now. Okay, you have to take a cookie now. For every second of silence, you have to take a cookie. Okay, so you can make some jokes about it. That might not be the greatest joke in the world, but it's a prop that you can distract people from the conversation from momentarily and then you can bring them back on target when you find better language, because you can think about it as they're grabbing, oh, you're right, okay, these look so good, they smell so good, and then you're thinking about how to ask the question better. Okay, so it tends to be social grease for people. Now the thing is, some people say, hey, look, this is a business meeting, everybody at that table is being paid to be there except me, and it's completely wrong that I've got to bring food. That's fine, that's okay. I just want you to make this decision knowingly, and so you can make an informed decision. Okay. So, but this is for the human factor at the table. Just puts people in a better mood. Okay. Now, let's see. Is it here? Yeah. So remember, additional factor at the table. In our experience and the experience of families that we work with, generally speaking, at the table, at the IEP table, there is at least one person who is on your side. Okay. People have shared with us that they feel like the psychologist is the one most likely looking to get a promotion. And as a result, they don't always feel like the psychologist is there to advocate for the student. Even some teachers may not be there to advocate for the student. But what we usually hear is from families is that they feel like some therapists, usually occupational therapists or speech therapists, advocate for the child, and usually the classroom teacher, the everyday teacher. Not always, but typically. And so what we tell people is, well, remember, because we hear from everybody else that there's usually some allies at the table, they're allies. So say some things during the meeting. When they say some things to support them. Perhaps they will reciprocate and support you. Okay. You want to develop those allies that you have at the table. You want to help them see things from your perspective. You want to get them to express things from their perspective while they're advocating for your child. So remember that factor at the table and think about who you need to support. You know who those people are. You don't need me to tell you that. Now, if you don't know who those people are, that's okay. Now you know to search. Now you know to look for those people or think a little differently about the meeting. So what this forces you to do is get a little bit out of your head. It forces you to get distracted a little bit from your game plan and instead focus on who's at the table. That's okay, do that. But then you've got to know your game plan really well. Well, that was part one. Part one, we talked about your game plan, how to introduce information at different parts of the meeting. So keep that in mind when you're working with people at the table. Okay, now the rest of this meeting, and we have about another, well, I'm madly looking for a clock. We have about another hour or so. We have to end by 11:30. We're going to cover statements that are made in IEP meetings that tend to stop parents cold. So even if you know your rights, even if you know the law, even if you know all this stuff, sometimes these statements get made and they just stop you cold. So what we want to do is cover those and give some answers and responses that you can provide. Okay. One of the things I would recommend is thinking about making flashcards for yourself, using index cards or something, or getting an app for your phone that will let you create flashcards on your phone. Okay. So here are the statements. We're just going to go through them. Your child simply isn't cognitively able to learn this material. The kid can't learn this stuff. Sorry. Okay. Excuse me. Thank you. Someone has to leave. I'm looking forward to watch the rest of the video. Yes, absolutely. Thank you. I'm glad you could join us for this long. Please don't feel guilty or bad about not being able to stick around. I get it. You have lives. Shocker. So I understand. Thank you very much for attending until now, and I hope you enjoyed the presentation. And again, yes, you will be emailed when the recording is available. That way you can view it and review additional information if you like. Thank you again. Okay, so your child can't learn this material. Sometimes we hear variations on this. Your child isn't motivated to learn this material. Usually we hear that in older grades, starting around 4th grade maybe, and then really seeing it frequently around 6th grade. even 8th grade. Your child has already reached their potential. We're done. Your child hit their limit. We're done. Not going to learn anything else. Fini. Okay. And we'll talk about how to respond later. So right now I'm just going through all those comments. We provide that service in that placement. We don't have to put it in the IEP. By the way, if you want to send me in the chat, if you want to send a message, because they're all direct message to me, it won't bother everybody else. Feel free, if you've experienced this, please say yes, or me too. Because one of the things is that I would like to be able to give feedback to the group. Right now, we have 36 participants, and I would love to say, oh yeah, we're getting a gang of yeses on this. Okay. One quick thing before we continue, we've got a question. Is there a way that I can use questions to get the district to acknowledge that Linda Mood Bell is better than Sunday, the reading program they have and are offering? So you can try using questions to do that. So one of the things you can do is ask questions to indicate that they are using an evidence-based program. So you can ask them questions about their program. Is it evidence-based? Does it have a practical application? Does it have this, that, and the other? The other thing is you can ask them what they know about Linda Mood Bell. And if they know nothing about it, then okay, they know nothing about it. But I think the outcomes are something that you can talk about in questions. Well, what's the average grade? What is the average grade advancement in the reading program? What does research indicate? Well, in Linda Mood Bell, do you know what the grade level advancement is for 3 months of instruction in that? From what I remember, it's about, what, 2 grades in one summer, typically? Not always, obviously, but typically. So there's that. The other thing is, we covered this a little bit last week, but not in a lot of detail, is the goals need to be constructed so that the gap closes over time, right? So the gap is, whatever the gap is, this distance here, hard to see, but this distance here is the gap between your student, your child, and typical kids, right? Sort of diverges. And over time, that gap tends to get bigger. And so what happens is, if a child in their special education program let's say they're 2 grade levels behind, just generally speaking, and they're you make an IEP, and over the next year, your child makes 1 grade level of progress, they're still 2 grades behind, right? The school district has an obligation to provide services that close that gap. So in 1 year of time, your child should be making more than 1 year's worth of progress, which may require certain kinds of services and certain kind of teaching modalities. Now, the thing I will tell you is that teaching modalities is one of the hardest things to get in an IEP, like choosing Linda Mood Bell over some other program. That is very difficult because there's nothing in the law that says that they have to use the teaching modality of your choice. But there are a lot of things around that issue that do indicate that there are some things in the family's favor, and a teaching modality should be chosen, like a specific one over another one, like closing that gap. There are other things. There are books on this information. FRCs usually carry them. They're certainly in libraries, and generally speaking, they're also on Rights Law as well. Rights Law sells a lot of publications. I'm not getting paid by them. I don't get free stuff from them. I don't get anything from them. I'm not saying that, just based on the input we get from a lot of families love and find the information on Rights Law very valuable. And they have books that you can pay for and purchase and that sort of thing. So, and to get to Rights Law, okay, someone's asking, can you mention how do I Google them? So for those books, I would look for something called Special Education Teaching Modalities, or Preference for Teaching Modalities, something along those lines. If you talk to your local FRC, I don't want to say I'm sure, but I would bet that their library has something on it. Okay, so let's get back to the presentation. So again, if you guys want to direct message me, yes, for each of the issues, I'll be happy to let you know. I'm getting a ton of them. I'm only getting a couple or whatever. And the reason why I'd like that feedback is so I know when we're covering the answer, the response, to spend more or less time based on how many people respond. So if you can do that. So your child, let's start with, again, your child cannot learn this material for whatever reason. They reach their potential cognitively, they're not motivated. If your child has had that experience, if you can send yes, that would be great right now. Right now I'm getting 0. Okay, so I'll move on. We provide that in that placement. We don't need to put it in the IEP. So we already provide that. So if you can send me, you don't have to send me yes, you can put in the word provide. How about that? We provide that service in that placement. We don't need to put it in the IEP. Has anybody experienced that? Just put provide in the chat. I'm seeing nothing again. Okay, this is very unusual. Okay, let's move on then. We can't do that. It's against our policies. It's against our contract. It's against our vendor agreements. We can't do that. It's against our policies. If you're seeing that, please put that in the chat. Say policies, I suppose. Got a big fat yes. All caps yes. Someone yelled it out. Anybody else? Okay. That would set a bad precedent. We can't do that. No way. That's bad. If we do it for you, we're going to have to do it for everybody. If you've heard that, one yes so far. Okay, just the one yes. That would be bad precedent. We can't do that. If we do it for you, we got to do it for everybody. Sorry. Okay, this is a draft IEP. This is a draft IEP. How many people have gotten draft IEPs? It already looked like they made up their mind. Okay, we're not getting any yeses there either. Okay, why don't we give it a try and we can have another IEP. Someone just sent a message saying, "Oh yeah, these are the responses we hear all the time." Got 2 yeses for this one. Why don't we give it a try and we can have another IEP? 3. All right. So this one hits a nerve. Yeah, okay, 4. So there we go. 5, yes to all. I'm not going to name names. I'm keeping the responses confidential. I'm not going to say who said what. But someone just said yes to all. Well, so why can't we give it a try, have an IEP in another couple of months, right? Okay, so excellent. All right. That's not a school-based skill. Doesn't happen at school, so we don't need to work on it. What are you worried about? It's not a school-based skill. We can't do it. All caps, yes. Just one so far. Okay. Especially for social skills, right? Social skills aren't a school-based skill, right? We can be antisocial and go to school, right? I say that completely sarcastically. Another all caps, yes. Okay. That skill is too advanced for your child. Come on, mom, you have to remember your child's limitations. Sorry, they can't do this. It's just too advanced for them. I got a yes with lots of exclamation points. Yeah. Yeah, this one's a lot of parents tell us that they feel terribly insulted when they hear many of these, and especially this one. Okay, we got another yes. Okay, very good. So here's another one. Why don't you ask regional center to do that? That's their job. That's something they should do. That's what regional center is there for, isn't it? 1 yes, 2 yeses, 3 yeses. We got an oh yeah from somebody, and all caps yes. Okay, they're piling up. So now if you didn't respond and you want to say like, yeah, I've seen most of those things, please feel free to put it in the chat and I'll be happy to let people know. Because or medical insurance, right? Yeah. Oh, right. Don't have, You may not hear regional center. That's a good point. I'm going to change the presentation to include medical insurance. So why don't you ask your healthcare provider to take care of it? That's something they should do. They have to do ABA. Why are you asking us? You can get it for free from your insurance. No big deal, right? Okay, so let's move on. In all caps, yes. Okay, yeah. Yeah, it is, because it's always about ABA when they go to medical insurance. Okay, so your child can't learn this material for whatever reason, okay, because of their cognitive ability, because of their developmental delay, because they're not motivated, because they've reached their potential, whatever the reason is. Now, one thing that I did when I started doing more special ed advocacy was, and when special ed had changed in the kind of advocacy that was needed, I made flashcards. I made index cards with these things on one side and my responses on the other. And I just memorized them. It literally took, now I'm fortunate. I'm one of those people, I can read pretty fast. I study pretty fast. I can learn things fairly rapidly. Although I'm not so good as I was when I was younger. But the thing is that I learned everything in this presentation in about a half an hour, and then I did a half an hour refresher. It really didn't take long. It might take you more time. It might take you less time. But the bottom line is you can learn this stuff. This is not terribly complicated. So your child can't learn this material for whatever reason. Now, because of cognitive ability, okay, that's a statement they've made. Because they're not motivated, that's a little different, because that speaks to attitude now. That's why we tend to hear it in older grades. For me, this is a big red flag, because this is then when you get the class clown label. This is when you get issues related to behavior. The thing is, what I found is that it tends to happen. We tend to hear this in older grades, like fifth grade on up, sometimes fourth, even third and fourth grade a little bit, but it really comes out around fifth grade and on up. Usually don't hear it much after eighth grade, after high school. Not after high school, during high school, we don't hear it too much. So here's the reason why. Generally speaking, at younger grades, children are learning how to read. And whether they do that at the same level or if they're a little behind or whatever, no big deal. All kids are learning how to read. However, in older grades, usually around fifth grade, kids are reading to learn. So this is an old educational phrase, or saying, which is, in second grade, kids are learning how to read. In sixth grade, kids are reading to learn. And this is true. Now, if they have not mastered the ability to read, they're going to be lost in those older grades when reading is required to learn other things. So motivation usually gets identified. Now, as kids have more and more difficulty learning stuff, they also tend to act out. They either turn inward and get depressed. They become the class clown. They become loud and exuberant. They behaviorally act out because they don't want to be found to be stupid. Nobody wants to feel stupid. Nobody wants to feel like they're the dumb kid in the class. That's a horrible feeling. And so kids mask that in different ways. So it usually gets identified as motivation. So then that's where I ask lots of questions surrounding the motivation. Why do you think that is? What do you see? What are some of the things you've observed? Et cetera, et cetera. Okay. Now, my response to this generally, or because they've reached their potential, that's someone who's just given up. Okay. A lot of parents have told us they feel like anybody who says that the child has reached their potential, they feel like that person is not a real educator. A lot of parents have said that they feel like that person isn't an educator because they don't believe in educating the child. They feel like it's done. And for a teacher, that would be a horrible quality. But this is the way a lot of parents report to us how they felt about it. So here's the questions. Now, one thing you may notice is that the questions themselves are, or rather, the responses are almost always in the form of a question. So remember, we believe questions are more collaborative. They create conversation, which creates evidence. So could it be we're not addressing a need in the IEP? Did we address them all? Because if the child can't learn this material, maybe there are other things more fundamental that we need to be working on. We can develop a goal for those things. So maybe we're not addressing everything in the IEP. Did we address it all? So these are the kinds of questions you can ask. Okay. Your child can't learn this question. So these are more responses you can give. Your child can't learn this material for whatever reason. Well, maybe there aren't enough services. Maybe we're not throwing enough services at my child, and so they're not closing the gap. And so it looks like they're not learning. Okay. So that's a good one. The other thing is you can ask, so sometimes what they'll say in response to your questions is, oh, we work on that informally with your child. We work on that informally. We don't keep data or anything, but we work on it informally because we recognize that it's an issue with your kid. Great. Did someone work on that issue with my child? Excellent. Can I see the data? Well, sorry, there is no data. We didn't keep data because we're working on it as an informal goal. So we just know it's kind of an issue. So we've been doing some stuff. That's great. But then I want you to get the credit that you deserve. If you're working on that, then why don't we construct a goal for it? And let's make sure we are taking data so that we can measure my child's progress. Because if you are working on it informally, I guess that means that you haven't seen the kind of progress that you would expect, huh? Can you tell me a little bit more about that, please? Questions generating evidence. So somebody just sent in the chat, could I have a PDF of this presentation? The answer is yes. At the end of the presentation, I'm going to put the presentation and all the documents into the chat, and you'll all be able to download it. I just don't want to do it. We've learned if we do this during the meeting, we end up, or during the presentation, I end up having to do it like 4 times over the 2.5 hours. So we're just going to sit tight and we'll do it all at the end one time. Okay. That doesn't need to be in the IEP. We already do that in that classroom, right? So this one, we had a couple of yeses, not a ton of yeses, but we do that in the classroom. It doesn't need to be put in the IEP, okay? So my response is, isn't the IEP supposed to be a portable document that I can take anywhere? I mean, if I move, and right now during the pandemic, my job situation, the things, we may have to move. And the bottom line is, if we move, shouldn't I be able to take my IEP anywhere and it gets implemented as best as the new district can until we create a new one? So if we don't put that in the IEP and I move, my kid's going to get screwed. So please put that service in my child's IEP in case we move. Thank you. Have another cookie. Please have some more, have another bagel. I don't want to take this food home. Please drink the coffee. There's nothing worse than letting good coffee go to waste. I bought the good stuff. I went to, and I got the really good stuff. So, please don't let it go to waste. So this is how you can bring in those props of the food. Okay. So portable document, can I take it anywhere? Okay. I want to make sure you get the credit you deserve. If you already do it, I want to make sure you get the credit you deserve. Why do you think I brought this food? I appreciate the work that all of you do. You all take so much time out to work with my child. Please, I want you to get the credit. I want you to see my appreciation. If it ain't written down, it never happened. So please write it down, because again, if I move, I want to make sure it's known. And then the other thing is I want you to have the credit you deserve. You guys work hard to work with my child, right? So you can make these kinds of statements. And again, remember, if it isn't written down, it didn't happen. So you got to have documentation. Now remember, all of this is good preparation to make sure you can avoid due process. Remember, to avoid due process, you got to prep for due process. Responding in this way. Now, the other thing is people say, well, then how do we make sure, like, okay, so all this stuff happens. How can we prove it happened during the meeting? Very simple. Record the meeting. That's it. Without knowing anything about anybody's case, my recommendation always is to audio record the meeting. Now with Zoom platforms and all that stuff, meetings taking place, you can do that. It's pretty easy. Okay. Now, if you can't do it, if they refuse to let you, well, here's the thing. Under the law, you can record the IEP meeting with, oh gosh, am I really going blank now? I just went blank on how many days notice you have to give. Somebody knows, feel free to put it in the chat. I want to say it's 72 hours notice. It might be 24 hours notice. Either way, my recommendation, give a week's notice. Okay, give a long time to tell the district, put it in writing, send it in a way you can prove they got it. 72 hours. Yeah, it is, right? So 72 hours is how much notice you got to give. Don't wait 72 hours. Don't wait 3 days before the meeting to send it. Do it a week before. Don't make it a thing where you got to panic to make sure it gets in the right person's hand at the last minute. This is not a ball that you need to hide. Just announce that you're going to record the meeting. You can put it down on the IEP meeting sheet. You know, the sheet that you get that says, hey, can you make it to the IEP on this date and time? Put down above your signature, I sign this with the understanding that I will be audio recording the meeting. Or this is to inform you that I will be recording the meeting. And then send another one a week before the meeting. Just don't take a chance with this stuff. Okay. But my recommendation is without knowing anything about your case, record your meeting, record your meetings, because their responses are going to be caught on tape. More evidence. Okay. Now, if you record it, they're going to record it as well. Okay. Don't record it without their knowledge. California is a state that it's a felony to record people without their knowledge. So, you know, bottom line, inform them that you're recording it. At the start of the meeting, say, yes, you got my thing a week before, you got my letter a week before this meeting indicating that I was going to record it. So I'm just letting you know I'm recording it now, and you move on and it's no big deal. Okay. We can't do that. It's against our policies, our contracts, etc. We got a lot of yeses, actually more than I typically see. So if the team makes this request, what you do, this strategy is a little different. So what you do is if they make the request, you ask that the IEP notes the reason why in the IEP. So we don't do that, you know, because of the policy. Just say, okay, can you please put down what's the policy, what's the union contract, what's the thing that says you can't do that? Please put it in my IEP. Then what you say is, you know, what I'd like you to do is, can you please put in my IEP that you will provide a copy of that union contract. I'm requesting that you give me a copy of that contract. How much time do you need to get it to me? A week? 2 weeks? No rush. Why don't you get it to me in three weeks? Okay. And then you get a copy in 3 weeks, hopefully. Now here's the thing. When you request that the IEP notes that a copy of the document will be given to you by a deadline, what you end up doing is creating IEP protections. If the district fails to implement the IEP as written, they're not following the law. That's a point in your favor. If the district fails to be able to produce it at all, it causes some doubt as to whether or not it existed in the first place. Point in your favor. Now, remember one thing is that the district okay, you know what, hang on 1 second, because now I see there's a question in the chat. Let me get to this and then I'll get back to that. So if school says we don't see that behavior here at school, or, oh, they can wash their hands independently here every day, are they not obligated to address a parent's request to work on that behavior skill? Actually, we're going to cover that question in a little bit. One of those takes care of that. So anyway, policy procedure. So here's the thing. Remember I said it's a point in your favor, point in your favor. It is rare in due process for special education to have a smoking gun. Okay, everybody says, oh, there's that one piece of information that's smoking gun. Here's the thing, very rare in special ed. What's more common is you want to create a case where you're just putting on straws on the camel's back. And finally, there's just so many straws that finally the camel's back breaks, right? That's what you want to do. And the reason why is because, like I said, rarely is there a smoking gun. A lot of times when someone says, if you point out that there's some big thing missing or some big fact or some piece of information in your favor, usually the judge is going to say, okay, but no harm, no foul. It's not that big a deal. It's just one thing. I mean, I get it. I hear you. There's something, but not that big a deal. You're done. You've lost your case if all you have is that one piece of information that you think is huge in your mind. Now, don't get me wrong, there can be things like that, but it's very rare. That is not common at all. The more common thing is it's the straws that broke the camel's back. So when I say point in your favor, point in your favor, point in your favor, all these things, all these strategies are designed to create a point in your favor. And so as a result, what happens is you end up building a case that is just incredibly difficult for them to defend against because you've got them on all sides. That's what you're creating, okay? Because think of how varied these strategies are. We're all over the place. We're talking about putting things in writing, asking questions strategically, having a response to particular kinds of questions, knowing when to introduce certain kinds of information into the IEP meeting at the right time to create the foundation. All these strategies interlock to create a case that is very hard for the district to defend against. Okay. So usually, but not always, they'll put these kinds of comments like, yeah, we'll give you a copy of the union contract within 3 weeks. Usually they'll put it in the comments. Not always. Sometimes they'll put it somewhere else. That's fine. As long as it's in the IEP and it's something that they're required to do. That's the important thing. Bad precedent. Everybody raised their hand. Everybody went, I was going to say everybody went crazy on this one. Okay, not, you know what I mean. There was a lot of exuberance in the responses. So that would be a bad precedent. We can't do it. If we do it for you, we're going to have to do it for everybody else. So my favorite response to that, this is basically quoting the law. This first question is, isn't the purpose of this meeting to design a program to meet my child's unique needs? Aren't we here exactly to do that, to create a precedent? Or I wouldn't go back to the word that they're using, but isn't that what we're here for? To find out exactly what my child needs to have their unique needs met? I mean, I thought that was the purpose of the IEP. What are we here for? Can you please tell me? Have another cookie. Thank you. Okay, so the other thing too is you may want to find advantages for the school to implement the request. Okay, so one of the things that I would recommend, like one of the things we caution people, never ask for a one-to-one aid. One of the most common questions we get is, how can I get a one-to-one aid for my child? And the best way to get it is by not asking for it. Now, this runs counter to everything else you hear me talk about. You hear me make your requests clear, make them plain. At the end of the presentation, we're going to go over some things to remember. That's one of the points. Thing is, with a one-to-one aid, I would say don't do that. Why? Because what's the first thing you hear? No. Everybody tells us the knee-jerk reaction to, can my child get a one-to-one aid, is nope, automatically, right away. And so rather than creating that nope, and now you got to get over that hurdle, instead, I would recommend you look at all the factors that go into why your child needs a one-to-one aid. They ran into the street, they left campus without supervision, they can't make it from one class to the next, they don't pay attention, and so the focus is elsewhere instead of academics, they need constant prompting for X, Y, and Z, whatever the thing is, okay, or things. And then write down advantages for the school to do what you need. Okay, write down the reasons why the school's going to want to do it. Well, that takes away a lot of the teacher time. And I know my child's not the only one in the classroom. And even though it's a smaller classroom, I know the teacher has to work with other people. So is that really the kind of distraction that we want to see the teacher have to manage? Do you really want to see my child get hurt on campus because they elude supervision on the playground? Do we want to see my child get hurt because they ran into the street? This is not a fear. This happened. There were 2 incidents in the past year where this had happened. Okay, so that's another thing. Don't speak to your fears. Don't say, but I'm scared that my child will. Instead, talk to examples and history and things that have happened. Okay, because that will score you far more points than fear. Fear won't get you anything. Fear will get you no. So don't talk about fear. Don't talk about I'm scared my child will run in the street. Instead, say, my child eluded supervision. They ran away from school campus and they ran on the sidewalk. But thank goodness that they were caught before they ran into the street. My child does not look both ways before crossing the street. That's not a skill my child's mastered yet. And thank God that didn't happen. Is that the kind of liability that the district would want to take on? No way. You guys are great. I brought food because you guys take such great care of my kid. Have another cookie. Okay. So bottom line is you can find advantages for why the school's gonna want to do it. And then what you do is because of those advantages, what you then do is you end up convincing them. And then when they say, well, we can provide this service, you can say, great, excellent, that's wonderful. But then if it doesn't meet the need, you can ask more questions. Yeah, but how is that going to take care of my child eluding? They're looking and plotting and waiting for someone to turn their back, and then they're out of there. So how does this address that issue? So by asking questions about if the intervention they are recommending is sufficient, when you ask questions, if that service is good enough, a lot of times they'll circle back and they'll come back to the very thing that you wanted, a one-to-one aid. So a lot of times the best way to get a one-to-one aid is by not asking for a one-to-one aid. Okay, there are some services like that, not many, but there are some. ABA might be another one like that. Okay, so one of the things you might want to do is go to Rights Law. They have an article called How to Ask for a Paraprofessional. It might be how to ask for a paraprofessional aid. But look at the article and they will describe what I just did in a little bit more detail. Okay, but I think you guys are getting the gist of it. Okay, draft IEP. So here in LA, we see this a lot. LA Unified tends to create draft IEPs. Many school districts around here do. And an IEP is okay so long as it's a draft. If they make a draft IEP, that's fine. There's nothing wrong with the draft IEP. But the problem is if they make a draft IEP and then refuse to change anything about it. If they refuse to change anything about it, then they've predetermined the outcome of that meeting. That's against the law. Okay, the law says they can't make decisions outside of the IEP meeting. They got to make them inside the IEP meeting. So if it's a draft and they've made a decision and they're presenting that decision to you as a draft and they're saying, but we're willing to change it. We really are. If you don't like this, let's talk about it some more and we can change it. That's fine. That's a draft. You're participating because the law says parent participation is required. Okay, that's huge. So if you're participating and they're wheeling and dealing and you're talking about it and all that stuff and changes get made in the draft IEP, no problem. If they refuse to make those changes, it might be predetermination. So one of the things you might want to do is ask some questions. I would not ask the question, is this predetermined? They know that word. Immediately, people will say, no, it's not predetermined. We didn't make up our minds before the meeting. No, no, no. Well, one of the things you can do to find out if it's predetermined is ask some questions like, well, when did this decision get made? Who made this decision? Where did it happen? Was there any discussion with other people? Was there, just get something to describe that this decision was made elsewhere and they're not willing to change their minds. Okay. The other thing is, remember, you can create your own draft IEP. Call it parent report, excuse me. Excuse me. So you can call parent report and make your own draft IEP. Very easy to do. Time consuming, but you can do it. Okay. Here we go. Everybody said yes to this one. Why don't we give it a try and we can have another meeting in a few months. So usually this is when there's a new service. Okay. Now, when I've asked parents, why do they think they hear this all the time when they hear when they're asking for a new service? And what we hear is parents almost always tell us because then when we've met a few months later, they terminate the service. They say, "Oh, everything's great now. Everything's perfect. Your child doesn't need any help with it. They're totally independent." And so then they find that the service has been discontinued. And so a lot of parents feel that this is a problem. Here's what I would do. Isn't the IEP supposed to be designed for 1 year? Why would we build it so that we meet again in a few months? I love you guys. I appreciate the job you do. Have another cookie. But why would we build this? You are very busy, right? Very busy. Someone just sent in the chat, have another cookie. Yeah. So, and that's why I love it as a prop. And so when we build it, and again, it's to demonstrate that you're being sincere. Like, but you might be referring specifically to only one or two people at the table, but the bottom line is you want to project that sincerity. You don't want to be fake about this stuff. That's why some parents tell me like they won't bring food because no matter what, they just still get angry and they just can't do it. That's fine. Okay. So aren't IEPs supposed to be streamlined? Another question to ask. Aren't we introducing another meeting unnecessarily? Here's the thing, the law says IEP meetings should be consolidated, which means you should have as few meetings as possible. That's why when you ask a lot of questions or you go round and round and round and you're fighting with them about a service, they're happy to do that with you a lot of times. Why? Drags the meeting out. Now we got to have part two, part three meeting, part four meeting. And over 4 months, 6 months, your IEP gets designed. It's not consolidated. It's not streamlined. So bottom line is, if they don't consolidate the meeting, they're not following the law. The thing is, you got to do your part too, which is why at the end, you may recall last week we talked about this, where if you get told no about a service, you get one chance to convince them of answering yes. We'll talk about that at the end of the presentation. And yes, wasting $12 on cookies sucks. Someone just put that in the chat. So that's not a school-based skill. So this gets back to that earlier question. We don't see that behavior here at school. That's a kind of a variation. Oh, they wash their hands independently every day. So it gets captured a little bit in this question and a little bit in, let me make sure it does get captured later on because too advanced, ask them to think. No, yeah, it's mostly here. So that isn't a school-based skill. First of all, this is usually about life skills. This is usually about things like eating, dressing, toileting. It's about washing your hands. It's that kind of stuff typically. So what you need to do is ask, how doesn't it happen at school? Okay, pretty simple. So now the knee-jerk reaction might be no. But look, if you're trying to get your child who's a little older, maybe say 7 years old, to do buttons on their jacket, and you get told, well, that's not a school-based skill. We don't need to work on that. To that, I would say, what? Wait, you're telling me my child doesn't go out during recess with everybody else? Or wait, are you telling me they go out but without a jacket? Who buttons the buttons on my child's jacket? Oh, well, I do that, the teacher. Okay, but I mean, you're introducing some stigma. Are they the only child that you end up doing the buttons for, or doing the zipper or whatever? I mean, aren't you creating some stigma with that? I mean, I really think that that's something that we should be working on because it does happen at school. And so you can do it that way. Now, the other things you can discuss for why it's appropriate for school is age appropriateness too. Is it really appropriate that my child has to have a teacher zipping the zipper in 8th grade? I mean, come on, other kids are going to make fun of them. We know how these things work. Oh, no, we don't have any bullying going on here at the school. Okay, I understand that, but it still looks goofy. It still looks weird. You're putting a stigma on my child because what, it's not a school-based skill in your opinion, and so my child is going to not learn that ability? That doesn't make sense to me. Besides, that's not consistent with what you all have done. You guys have worked for years to educate my child. Have another cookie. Thank you. I don't understand why you would break from that tradition now. Okay. So, age appropriateness, ability to further education, employment, and independent living. You can certainly do that, right? So, this is where social skills, right? Somebody mentioned earlier, especially about social skills, not a school-based skill. Social skills absolutely are. Without social skills, how can your child get a job? How can they live independently? I see that more related to employment, though. So, if they can't work well with others, how are they going to work? We can get a job coach to work with my kid. We can get a job developer to help them find a job. But look, if they want to punch people in the face when they get frustrated, instead of saying, I'm angry with you, then, or instead of saying, I'm upset and I need to be alone for a moment, how does that not impact the child on the job when they're an adult? How are we preparing them? OT said my child doesn't qualify, and yet my child cannot button their pants, and my child's an eighth grader. There you go. It's exactly speaking to the point. I'm sorry that's your experience, but hopefully with these advocacy strategies, you can get that. So if you can connect it to further education, post-secondary education, college, junior college, university, whatever, trade school, all good. Or if you can connect it to employment or to living independently. So independently from like living in an apartment, preparing your own meals, going shopping, managing the books, with assistance. Regional center can provide that assistance, but the person's still going to need some skills to be able to do that. Okay, so point to those things and use those as how they are school based. Now, I want to make sure I answer this question directly. If the school says we don't see that behavior here at school, so if they don't see the behavior at school, that's tough. That's really tough. My only real suggestions on that are volunteer at the school so you can see it happen there. They'll kindly ask you to stop volunteering after a certain point. At least that's the experience that we hear from many families. They report that. The other thing is you can see if you can get that data through other sources. Okay, so for some of the goals, one of the things you want to write into the goals are that data collection will happen. Formal testing instead of teacher observation. You want to redirect it to things that are objective that we can look at later. And so you want to try and get stuff or data collection for behaviors and other things that may occur. The other thing that helps is letters of understanding. If you've got a letter of understanding, like remember I talked before, someone asked, well, what if there's an incident that happened? Do I want to document that incident? Heck yeah, because that incident, that behavior is when it happens at school, you've got a letter of understanding. You can demonstrate it happens at school. So you've got to get clever about the kind of strategies you use to demonstrate it does happen. Okay. The other thing is washing their hands independently here every day. One of the things you can do is ask for progress updates, communication logs, simple communication logs, where did the child wash their hands independently that day? Because my child came home and their hands were filthy. Okay, so you can ask for a communication log to back up learning at home, to support learning at home. And then what happens is that communication log becomes evidence. My recommendation is if the school does agree to do a communication log, that's take a photograph of it every single day, because if it gets lost, you lose the evidence. And basically don't use the log as a place to argue or any of that. Just use it as a place to document, to ask questions, to get information, because that's your objective here, is to get that information and demonstrate it does happen at school. Okay. All right, that skill's too advanced for your child. Establish that there's a need. Establish that your child can't do something. Okay. And that we can develop a goal so that they can learn how to do it. Learn the developmental milestones. Okay, when they say too advanced, they're usually saying that of younger kids. So learn these developmental milestones, which we will drop in the chat. Okay. Learn the Common Core standards. You might remember last week I talked about sometimes the best goals aren't goals at all, but they're goals that you swipe from the Common Core standards. So if a child is expected to be able to do 2-digit multiplication in math for their grade level, I believe 2-digit multiplication, what is that, 6th grade, 7th grade, something like that. If you want to have your child make sure that they can learn the same stuff as everybody else, put that down as a goal. You can do that. And then it's not too advanced for your child. It's a goal that they're working towards, just like anything else. Okay. Why don't you ask Regional Center or your healthcare insurance to take care of that? That's something they should do. So again, it's the difference between adequate versus optimal. Okay. Regional centers have to do optimal, schools have to do adequate. However, you need to tie it to the child's education. So it's true, there are some services that overlap that the school can do and regional center can do. A lot of times people feel like they don't get enough of that service from one system, and they need both to get to the level that their child needs. In that case, turn it back to making it an education-based request for the service. So that gets back to the button, the jacket at school when they go outside for recess kind of thing, or lunchtime, right? You want to take it back to these questions. Now moving the slides back a little bit. To these questions. It's not a school-based skill. Well, make it a school-based skill. Demonstrate that it happens at school, okay? And you use much the same techniques as these that we talked about. Social stigma, age appropriateness, the ability to pursue further education. By the way, the ability to pursue further education, employment, and independent living is part of the definition in special education in the law. So in the law, it says the purpose of special education is to enable students to pursue further education, employment, and independent living. That's the very purpose of special ed. So bottom line is that you can invoke that in order to get the services that your child needs. Okay. All right, moving right along. I think we're back at the end now. We've got about 10, 15 minutes. Some things to remember. First of all, always put requests and concerns in writing. Okay. Now, remember how I said you don't want to ask, like if you're going to ask for a one-to-one aid, don't ask for a one-to-one aid. So this is kind of this kind of goes against that, but this is a little different. Put down all your concerns in writing that lead up to request the one-to-one aid. Just don't make the request for the one-to-one aid. And as many of you will be able to see, Tamika right now is dropping in some of these files into the chat. So you guys will be able to get these things into the chat and, or excuse me, download them from the chat conveniently and easily. I'm going to drop this presentation into the chat. Oh, wait, that's a direct message. Let's get it to everybody. And boom, it's going to get up there. If it's not out there now, it'll be there in a moment. Okay, very good. So couple things to remember, put those concerns in writing. So again, you may not want to ask for a one-to-one in writing, but you may want to put down the reasons why you want that one-to-one. Okay, always write letters of understanding, prove that they were received, clearly voice your disagreements at IEPs. Again, my recommendation is to point out the disagreements when they exist. So when you ask for something, they say no, you should ask them why. Why are you saying no? Take notes. Then take one opportunity, one chance to try and change the team's mind by addressing those those points that they use, the reasons why they use to deny it. So address those things and ask questions, use all these techniques. Take one shot at requesting the team consider it again. Once they say no, well, your job as a parent is to get yes or no from the team. So once you get a yes or a no, move on. But until that point, demand yes or no. Now, the way I would demand it is I'd say, I'm sorry, after all that talking, I don't understand if that was a yes or a no. Was that a yes or a no? I don't mind looking dopey. I don't mind looking like I don't understand. Sometimes I don't understand. So what? Who cares? Okay. So I will voice those disagreements. I will listen to the reasons why they said no, and I'll take one shot on convincing them. After that, move on. They'll appreciate that too. Okay, well, please note my disagreement. Again, I disagree with this decision, but let's not belabor the point. Let's move on. Thank you. Have a cookie. And then you're done. Okay. Now you can appeal it later in due process. Okay. Right here is an article on the difference between adequate and optimal education. You don't have to believe me and take my word. You can read about it. Never, ever, 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 ever sign the IEP at the IEP meeting. The law says you must sign it within a few days. And it says, I think it literally says within a couple of days. Bottom line, my recommendation is never take more than 5 days to sign the IEP. Okay, if your IEP meeting is on Monday through Wednesday, get it back to them signed by Friday at the latest. If your IEP is on Wednesday, Thursday, or Friday, get it back to them by Monday at the latest, which means you may have to make some phone calls. So call people, talk to advocates, talk to lawyers, whoever you need to. But if you only have 2-3 days to act, that's very short. Okay. Now remember, you can give consent, you can withhold your consent. When you sign it, a lot of people seem to believe that when you sign it, that means you're signing an agreement. No, that's not what happens. You can do that. But instead, remember, you can give partial consent, full consent, no consent, nothing. If you withhold your consent, the team must implement the last agreed upon IEP. Okay. So we had an IEP a year ago. You signed off on it. You loved it. You liked it. Everything was great. Now today you had an IEP. They want to cut a bunch of services. They want to introduce services you don't want. You just don't like this IEP at all. You can say no to the IEP. So you sign it. You say, I sign this IEP in complete disagreement. I do not give my consent. Real simple, real basic language. And then what happens is they have to continue implementing the last agreed upon one, which was the one from 1 year ago. They have to keep doing that until the disagreement is resolved from this meeting. Well, if you don't ask for due process, if the school doesn't ask for due process, there's no resolution to the disagreement. You will continue getting those services as long as you continue to disagree with the new IEPs. So that's why your IEP never has to get any worse than the best one. Whatever the best IEP was, it never has to get worse from there. Okay. Now, one thing is if you're asking for a new service, we talked about this a lot last week, but if you're asking for a new service, make sure that you no, let me back up. You ask for a new service, you want 2 hours of this service a week. They only offer you a half an hour of the service. What you can do is give your consent. You can say, I provide my consent to implement 1/2 an hour of occupational therapy, but I disagree with the frequency, quantity, and duration. Okay, one more time. I'm repeating it so you can write it down. I give my consent to implement 1/2 hour of occupational therapy, but I disagree with the frequency, quantity, and duration. I disagree with the frequency, quantity, and duration. Okay. Remember, questions are collaborative. Yelling, accusations, no. There's lots of resources here. We dropped it in the chat so you guys can look at that. Lots of articles you can read. Again, these are things that can put you on the path to becoming an expert. And that's basically the presentation. If you'd like to send some questions to me, I'll answer the few questions that we can. I'd ask that you stay on the line Okay, stay on Zoom right now, because we're going to put up a poll, and in that poll, we're going to ask you a few questions, mostly centering around who you are and if you enjoyed this presentation, what we can do to improve it. And if you do have tips for me to improve upon it, I would really appreciate that, because I want to give the best presentations possible. And so that poll will come up in just a moment. In the meantime, I'm going to pull a few more pieces of information for you and download it. Let me make sure. We've got the bullying, we've got the developmental milestones, so we need the IEP strategy guide. So let's drop that into the chat as well. Boom. And that's for now. Okay, couple more things about and so Tamika, if you can pull up the chat, that would be great right now. Or pull up the poll, rather, excuse me. And let me stop sharing, because this is a little annoying. There we go, and the poll's up. So if you all could please take some time to fill out this poll as best as you can. I can't see who put what answer down. It is anonymized as far as I know. So we'll see the results. And then when the poll's over, I'll show everybody the results so you can see who everybody is and all that kind of stuff. I'm going to talk about one other point, which is some things and strategies to do right now during the pandemic. Number one, you should keep a log of how much time your child is staying at the computer and is engaged in distant learning. Okay, you should time the number of minutes of services that they provide a service and how they're provided. What way? What are they doing? You want to note how much time, how much and the types of interventions you as a parent have to provide to support your child. You want to make videos of your child learning, of being at school, literally when they're attending distance learning. You want to film that. If you plan as a parent to build a district for the educational support that you provide your own child, you can notify the district that you intend to do it and include documentation of what you're going to do and for how long. So that's really important. If you're doing educational support, remember, you have a right to a free, appropriate public education. If you're providing work for free, your child's education isn't free. There's a cost, your time. And so that's what you can do. You can note that and document that. All right, and I can see still filling out the poll. There are 30 people still here, and on average is about 15, 17 responses for each of the poll questions. So I'll continue giving you more information while you fill out the poll. A lot of people have had success. I shouldn't say a lot. Some people have had success getting services in the home by getting the district to provide the service through an outside agency. Okay, we call those generally non-public agencies, NPAs, non-public agencies. So like if your kid needs speech therapy, school district won't do it, can't do it because of the pandemic, they won't send their staff into people's homes, then you can say, well, I'd like to get that through a non-public agency, and I'm requesting that at your IEP meeting. And basically, if they do, there might be some agencies willing to come to your home, and then you can do speech therapy, you know, in your backyard or on a balcony or someplace that's safe to do so with masks and the whole 9 yards. There are concerns from people, and it looks like we might be getting as many responses as we get. There are some people who are familiar with Stay Put. And so remember that last agreed upon IEP thing? Well, that last agreed upon IEP, what if your last agreed upon IEP is today and it's during the pandemic and distant learning and all that stuff? What happens when the schools reopen for instruction, in-person instruction, and your IEP, your last agreed upon IEP is all distance learning stuff. So what a lot of parents are doing is they're asking the district to put in the IEP that, or to make an addendum and put and add to the IEP that the last IEP, the last agreed upon IEP for stay put purposes is the IEP from, and then you give a date. And that seems to be very helpful for folks. Oh, we're still getting some more answers. This is great. So so there's that. The other thing is, yeah, those are pretty much the biggies. Let me see what else. Oh, another thing. The law indicates that families, parents can get training as well. So you can write into the IEP that mom and dad will be trained in ABA. You can write in the IEP that mom and dad will be trained on X, Y, and Z, whatever it is. And so keep that in mind because you can ask for things for you. Okay. And for kids who, for those of you who have kids with a regional center case, you might be able to get behavioral respite during school hours that are paid for by the regional center. And of course, the regional center is going to ask you to use generic services first and all that kind of thing. But if those generic services are not available to you, then ultimately it's a denial. It's a denial. And so you have the right to ask regional center for those services. Okay, so let's get to the poll and I'll show you guys. By the way, thank you for your thanks. Somebody thanked me and said it was a great presentation, which I really appreciate. And so I'm going to end the poll and now I'm going to share the results with everybody. Actually, let me take a photograph of everything because I want the outcome for my own self. Okay, now we're sharing the results. So we can see there are two people here advocating for themselves as self-advocates. The vast majority, I shouldn't say the vast majority, the majority are family members, and then we've got a large number of professionals here as well. As a result of this activity, all of you agree that you're going to have more advocacy skills, which makes me ridiculously happy. Pretty much just made my day. All of you have said that you're able to better say what's important to you. Many of you are already participating in advocacy activities, which is awesome. Keep it up. Some of you are members of boards or committees or advocacy groups or some kind of leadership position. We frequently see this with parent support groups, which is awesome. Okay, everybody was happy with this training. Yay, thank you. For some of you, this is the first time you've seen any SCDD people. Cool, or I should say attending an SCDD event. So hooray, glad you could join us. I hope you plan on coming back again based on this training. And then let's see, the majority of people are Latinos, and we have some people who are Black. We have some multiracial people. That's me. And then we have the occasional white person, Asian, and Native American Indigenous person. So pretty awesome. The vast majority of people here are identify as female, and many of you work in the field, which is pretty cool. So I'm going to stop sharing the training right now. We're going to end the presentation. I do again want to remind you that the flyers have been put in the chat for for our future trainings, the one that's taking place a week from today on evaluations. We're going to dig really deep on evals, and then the one that's taking place in January on how to do a state compliance complaint. So our pleasure. So we're getting a couple of thanks in the chat right now. And so I just want to say to everybody, it was our pleasure doing this training. The best reward is knowing that you're going to be able to use this information and that it will help you. And so good luck to you. Tamika's just put in the chat the evaluation training. And so please, I'm gonna vamp it up a little longer on the call so that you guys can download those two flyers right now. I see there's a raised hand. And so why don't we have, okay, wait, let's see who raised their hand. There we go. And I will invite you to unmute yourself and you can ask your question. I'm going to have to make this the only question though, because I'm doing this exact same presentation in 25 minutes and I got to rest my voice. I got to eat. And so I would ask for your patience for that. If you do have questions, you can email us the questions and we'll be happy to help out. So Marlon, what's your question?
Hi, well, my question is, can we disagree to a draft IEP for, I had an IEP, my yearly IEP, but it was the yearly one, and then to review the results for the IEEOT. But since I had a family member that passed, I only reviewed the OT assessment, and I couldn't continue with the IEP. How can I disagree to the rest of the draft?
So, well, it depends. I mean, it depends on a lot of factors. Number one is if the meeting ended. So after you covered that part, if the meeting ended, then there is no disagreement needed. There should be another IEP to continue the conversation. If the meeting didn't end, when let's say the meeting continued and you were present and you just weren't prepared to talk about it or anything, that you would have to disagree with those things the way you would disagree with anything else. So I would just say, look, what are the reasons why that decision was made? Okay, did you consider the following factors? Take one shot to change their mind. And then if they say, no, we're sticking with our decision, say, okay, that's fine. Please note my disagreement in the IEP. Let's move on to the next item. The thing is if they refuse to change anything about the draft, it ends up being predetermined. That could be evidence in and of itself that they decided before the meeting. And so if they decided before the meeting and you can prove it, that's a tremendous piece of evidence on your side. That's a very large straw that will break the camel's back.
So just write down, I agree with the review of the IEEOT assessment and disagree with the rest of the draft?
Yeah, when you sign your consent, you can say, I agree to the, whatever service they agreed to provide you. And you can say, I disagree with everything else. And they won't be able to do anything else.
Okay.
So in that draft IEP, whatever that IEP, however it got finalized, if you state that you're not giving your consent to it, they can't implement it. They can't do it.
Got it. Okay, thank you.
Sure thing.
Well, thank you, Chris. I wanted to thank everybody for their participation today, and let's give a round of applause for sure for Chris for taking the time out. We do hope to see you guys next week for the next training and also for the one in January. I would definitely register because they are filling up pretty quickly, especially those two. So with that, we're going to go ahead and end the presentation, and we will be sending out all the materials along with the recording after the training today. So thank you guys, and have a good day. Be safe.
Thank you.